I followed him when he traveled. At exactly 1:15 a.m. this morning, I called him. I was awake because I was monitoring him. I called him. I said, Marshal, how far? He said he just entered his house. So if he was not interested in getting the guy out, he would not cut short his trip. And when I came in this morning, I was still chatting with him this morning. When I came into court, I met Femi. I said, this is the message that Masha sent to me. Masha sent me a message on WhatsApp that, hold my brief, should in case I come late to court. So, and I showed Femi, I said, this is the message, this is what Masha said. He said no, that he was going to lead. So, and I said, call Masha. He refused. I called Masha in his presence, put it on loudspeaker, and Masha said, I'm already by the court. I want to enter now. And this guy was hearing it. So, when Masha entered, the judge gave a hint that if Marshal withdraw his appearance, automatically whatever he files is going with him. And Femi was sitting down, still challenging Marshal's appearance. And it will interest you to know that Femi and Marshal, they appeared together on the day of arraignment. So I expected that immediately Femi saw Marshal, he was arguing with me, which is fine. But immediately he saw Marshal, he should just allow him. And when the judge gave the hint that once you withdraw your appearance, anything you file is going. And what that means is, that means the bail application will not be held today.
Okay, to save time.
And he saw it.
Sorry, sir, to save time and otherwise. The argument is normally the Femi and Marshal have come to terms and condition that
is why
I'm the leader of
that is why you should have been here listening to what he said.
The argument. That's what I said. So it is very, very clear now. We now satisfy.
I also had that in mind. That's why I asked him to address this, because the point, what I heard was clear.
Yeah,
Mr. Marshal, we do restrict us.
Please, let's stop the argument and let us
Okay, so I say that. Wait, I say that the interest, the main importance of this case is to free Justice Clark. Why do you guys still withdraw the case after you say that your main interest in this case is?
That's a beautiful question. Absolutely. Questions on the limited Nigerians now.
What happened is, what happened is, I think there's an agenda. Immediately that people saw Marshal travel out of the country, they saw him with VDM. Something transpired behind the scene. They went to DSS custody. The guy was in DSS custody, met him in DSS custody, and obviously poisoned his mind. So when the court now asked the defendant, Justice Clark, who is your lawyer? He pointed to Femi. It was at that point that since and Justice Clark was aware that Marshal filed this bail, Marshal appeared for him. I was with Justice Clark's wife on the day we filed this bail application. We were running around. So immediately, since Justice Clark disowned Marshal in the presence of everybody in the open court, what does it mean? It means that I don't want you to be my lawyer.
This Marshal and Justice Clark issue that is currently trending online, I will tell you a story. There was a time my boss sent me to Court of Appeal to handle a matter. And of course, once you enter the court, before the court starts sitting, you have to write down your name, year of call, and who you're representing. And I wrote down the name of my principal and his year of call together with my name, but I did not include my year of call because it was my principal that instructed me. And just as it's done, matters will be called out of turn, following seniority at the bar. So, of course, my boss is someone that is already like 40 years plus at the bar. So his matter was called first. And I stood up. And the learned justice said, "What's in when? Were you called 19? He called." I said, "No, my lord. That is my principal." And my lord said, "Sit down. You cannot use his influence to handle matter before your senior seated here." And immediately I said, "My lord, my principal is on his way. They have to wait till my principal entered." I said, "My lord, I'm here," because he was just climbing the stairs. You see? So why did I make this scenario? If you will listen without sentiments and emotions, if from what is trending online that Femi was instructed by a senior who is also senior to Marshal to handle that matter. And in court, the senior is not present, there is no way Femi would lead marshal. It's not possible. Unless if that senior is in court, it's a different ballgame. It's a different ballgame. But for the fact that it was marshal that led at the last adjourned date, what they would have done, since there are disagreements as to who to lead, and seeing that the person with yam and knife is marshal. Because what is the business of the court? To move an application. That is why they were all there. What he would have done, which was reasonable to me, is to allow marshal to lead or ask the court for a stand. I'll quickly ask the court for a stand down, go outside and call my principal. This is what is happening in court too. Marshal said he will lead and there are disagreement. What my principal will say is allow him to lead for the purpose of that bail application. By the next adjourned date, another person can take over because every person charged with a criminal offense has a right to counsel of their choice. That is what Section 36 sub C 1999 Constitution, that is what it states. Every person charged with a criminal offense has a right to choose any legal practitioner of their choice and also have the right to change at any time before judgment. But however, for every institution, we have rules and regulation guiding it. By Rule 29 of the Rules of Professional Conduct, there is a guideline that guards all legal practitioners. By Rule 29, before you can take over a brief that is being handled by another person, another lawyer, you must formally inform that other lawyer. You that you are the incoming counsel, you inform the outgoing counsel that I am taking over formally. And it doesn't stop at that. You also make sure that any other fees, they are addressed. Probably if your client is owing the other lawyer who you want to take over from, if there are fees that are unpaid, you must make sure that those issues are addressed. You don't just come and take over matter like that. Your first duty is to court, your other duty is to your learned friend before your client. For someone who has taken up a matter on pro bono cases means that at least there was an iota of humanity that you must have extended to this person. For once, I want Justice Class to be out of that custody. But I will not do that at the expense of my integrity. There is what we call seniority at the bar. If marshal has allowed them or say, okay, let's even address it like this. Listen, now there is no other counsel on record aside from marshal. So if marshal withdraw his appearance, how would the bail application stand without a counsel on record? You can't just enter the court and say, I want to move an application when the person who has started the matter, whose appearance is on record, has withdrew his appearance. There is no formal change of counsel to say, okay, you are now qualified to take over the matter. You don't just appear in court like that now. It doesn't happen. So even if he leaves that bail application, let's say the bail application succeeds, who would have moved it? There is no counsel on record. You don't change counsels orally. There must be a process, motion or notice for change of counsel, which will be served on the court and the other counsel. And if issues like operational fees are not addressed, the outgoing counsel has a right of lien over the case file of that client. So this is no issue of sentiments, emotions, or anything. A lawyer will do everything within his power to protect his integrity. I'm not going inside. The fact that he even withdrew his appearance was the right thing to do. Whatever that happens afterwards was just consequential. Is the consequences of withdrawing that appearance. So I want us to see it from the light of what does the law say. Aside from sentiment, it is wickedness, it is emotions and all of that. And to even make this thing more clearer, the judge gave a hint. I mean, Marshal has found it worthy to come and give his side of the story. The judge gave a hint that if Marshal withdrew his appearance, that means every other application goes with it. The judge gave a hint. What would the other lawyer have done in that circumstance? To say, my lord, I will allow my learned friend to lead. If actually we are all interested in humanitarian deeds. I know you might say he took the matter pro bono. Even if he takes the matter pro bono, the rule is the rule. Maybe professional fees will not be addressed because it's pro bono. But what about change of counsel? What about putting it on record? What about the formal notice? All of those things has to be complied with. If you must listen to anybody in this matter, listen to a lawyer and listen to people who are present. And I think for what it is worth, that the other lawyer should also come and give us account of what happened. Or we draw conclusions from what Marshal has said. Because any other thing you people are saying there, I might not be interested. Because whatever I'm taking out from Marshal, I presume I'm taking it out from the horse's mouth. And I'm a lawyer and I know how it feels. I cannot allow my junior to lead me. It is never done. There is something called seniority at the bar. If the other lawyer is claiming that a senior instructed him, that senior is not in court. And I'm the counsel on record. Yes, if he does not want Justice Clark to be out, he won't have cut his vacation short. Where I may say that Marshal would have done better was in communication. From what people are saying, there was break in communication. They were not hearing from him and all of that. But in this situation, as it stands in court, the junior lawyer would have stepped down for him to continue. It's just for that day. Yes,